there is a feeling that perhaps you're not quite sensitive enough in terms of procuring proper coverage of all areas. You've said that you are concerned about coverage. Can I just put this to you? If there were one practitioner in North Wales practising publicly funded law in a specialism, and that firm did not actually have the required throughput by dint of the lack of population in North Wales in comparison with other places, what would be your attitude towards granting a contract?
Well, we do have a number of minimum contract sizes, you're correct. Sorry, I'm not sure I heard you. Did you say public law children? Or,
no, I didn't say children.
Generally.
Has the process finished? Have you awarded all the contracts in other forms of
yes.
law? Well, I'll be direct then. There's one mental health practice in North Wales who are very highly regarded. They are the only practice in North Wales, and they're certainly the only practice in the whole, the upper half of Wales, if not the whole of Wales, to provide Welsh language services. Were they granted a contract by you?
I'm afraid I can't possibly answer that without knowing a bit more about who they are. I
Well,
wouldn't have all that information in my head, I'm sorry. I can take a note of it and follow that up.
Well, I would ask you please to do that. I won't put you on the spot now. I can tell you at the conclusion of this committee precisely what I'm talking about. It's of grave concern in North Wales, let me tell you. Moving forward, can I refer you to some of the criticisms that has been made of the whole contracting process and the impact on service providers? It's been said, for example, that information for applications was issued 6 times during the tender process, and that key tender information and criteria were not available until the tender opened, thus making it more difficult for potential bidders to prepare. Further, that at all stages of the process there was difficulty because bidders were finding it difficult to prepare for tender, for example, ensuring that key staff were available for key stages in the process. And it goes on. The CAB have noted several errors and so on. The Commission, it has to be said, has previously been involved in flawed tendering processes, such as the Immigration Removal Centre tender in March 2009. Why were lessons not learnt from that particular episode? And are you confident that you will learn for the future, bearing in mind what we've just been talking about?
On the immigration removal tender exercise in 2009, yes. A full independent review was undertaken after that tender basically just didn't proceed. And lessons were learnt. Those lessons learned about having specific individuals who had responsibility for leading a specific tender programme within the Commission that was adhered to, actually ensuring that if the outcome of the tender exercise was providing results which you didn't feel met your objectives, that you shouldn't proceed, which is what happened in that case. So yes, a full review was taken. In relation to the current round of tenders, and particularly the family tender, then we would expect to have, again, an independent review, and that we will definitely take on board with colleagues in the Ministry of Justice and indeed with representative bodies who would want to be involved in that exercise and that review. And yes, we will definitely take on board the lessons from that process. In relation to some of the issues that you've raised about the issuing of, on 6 occasions of application, information for applicants, I am aware that we did make some very minor amendments to information for applicants.
Well, you invite me to interject.
Yeah.
The CAB told us, in fact, that questions were asked seeking clarification, sometimes receiving wrong answers, and the question being why was the information issued so many times. They were very unhappy to such an extent that they made a point of telling us about their unhappiness. And it wasn't minor stuff as far as they were concerned.
I think we'd be very interested to understand exactly what their concerns were, because they weren't actually raised with us during the process, certainly in relation to any wrong answers on the FAQs. We actually worked very hard with the representative bodies, and in particular Advice Services Alliance that represents CAB and other not-for-profit providers in negotiations with us, to make sure that there was sufficient information, that we felt it was clear. The changes to the family information for applicants that you identified were partly as a result of requests from representative bodies and others. I'm not aware of any incorrect answers to FAQs, but again, it's certainly something I'm very happy to follow up with you in writing. We have tried our hardest to make sure that we have answered the questions correctly and appropriately. Might be worthwhile considering the context of the tender process. There were some 5,000 bids in all 14 civil categories over the summer, so there was a lot of information. I think sometimes we have provided answers grouping together a series of questions to avoid information overload, and that may mean that some specifics of any particular question are not actually answered, but I'm not aware of any incorrect answers.
We will give you access to the CAB's evidence, which will be published in the end anyway, so that you can you've got an opportunity to answer the specific charges that they put against you.
In light of what the Chair says, I'll just also refer to the fact that the CAB said that there were delays at virtually every stage, and in some cases staff had been made redundant before they heard from you because of the delays.
There were some delays to the process. I think Ruth just explained the fact that we did have 5,000 bids. In many instances, the quality of the information that we received needed some significant clarification, and therefore that did take time because we didn't want to prejudice anybody in the process. So we had to seek clarification. That did take time, and therefore there were delays that arose as a result of that. One, the bulk of applications and tenders that we received, and two, the clarification of information that we then needed to undertake from many of the bidders. In terms of people were made redundant, with the tenders were due to be awarded in October. With all but family, the tenders were made in July. All the awards were made by July at the very latest, and therefore the instances where it would have been late were very, very few and far between, and that would have been to providers who had tendered at the first round, not been awarded a contract or sufficient amount of matters, and then through verification and appeals processes, then they will have come back into the process. So there will be a few instances where people were informed very late in the process because some providers who'd been given a large number of matters stars on verification decided that they didn't feel that they wished to undertake that level of work. That was handed back to us, and we awarded back then to the people who came next in the scoring mechanism.
That, I think, follows on neatly to my next question. When I was at school a long time ago, one of the skills we were taught was how to prepare a précis. Why then were the 2010 criminal and civil contracts 273 pages long and 363 pages long? Surely it would have been simpler, and it could have been simpler, and it could have been shorter. And if that had happened, then the problem we've just identified in the previous question might not have happened.
Shall I take this one? I don't think there's actually any connection with respect between the contractual documentation and the failure to put in wholly accurate tenders.
Your colleague thought so, but
they're entirely
you
different.
disagree with each other, I suppose, do you?
I don't think we do. They're entirely different documents.
Right.
The contracts are actually prepared in conjunction with the representative bodies, in particular the Law Society, LAPG and ASA, Advice Services Alliance, I referred to before. And we worked together on the 2010 contracts. Actually, I don't believe they raised any concerns about the length. What we were focusing on is trying to make them as simple and straightforward as possible. And it is true that we produced a single set of standard terms which apply again across all of our contracts now, which means that providers who do both civil and crime only have to look at the one set of standard terms. And they're also a lot shorter and simpler than the 2007 set. What that did mean, though, is that for the specification, which are the rules, if you like, of how to do the legal aid work on the ground, we had to put other rules to do with civil in the civil specification and likewise for crime. Now, that has meant that they are a little longer, but the advantage to providers is that the rules are all in one place and readily accessible. And we thought, and I think the representative bodies agreed with us, that that could only be beneficial because it should enable people to avoid making errors.
Thank you.
I was interested in the issue of overpayments, if you like, which has been a continual problem. In your opinion, I mean, forgive me, I'm no lawyer, but it seems to me to be an unbelievably unwieldy document to have to wade through in order to contract with you. Do you think the length of this document is in somehow related to the problem of overpayment, which appears to be an issue of people being paid in error rather than fraud? And what attempts are you going to take to try and simplify the process? A, to improve this process, and B, to drive down, I believe it's £30 million of overpayment running fairly consistently every year.
Our accounts have just been laid today and it's actually nearer £80 million.
£80 million of overpayment. So how linked is this unbelievable wodge of complexity that you're putting into the first stage of the contract with the overpayment problem?
I think the overpayment problem, the very large majority of overpayments result of wrong claims and errors in the claims from providers, and I think that that does absolutely relate to the complexity of the fee schemes that we have. The Ministry of Justice have made it clear in their Green Paper that they would wish to seek to simplify the legal aid process as a part of the legal aid reform programme, and we will be very happily working with them to try to do that. But one thing I think it's, and I really don't wish to sound in any way defensive, but the graduated and fixed fee regime, which has created complexity in the whole claim system and the whole legal aid system, it should be remembered that that has saved about £500 million worth of monies by introducing that regime. So it has increased complexity, it has without doubt increased bureaucracy involved, but it has saved considerable monies on the legal aid fund as well.
We're coming back to the accounts and, the qualification a little later. Mr. Gunn.
Thank you, Sir Alan. Could I ask a supplementary on that, which is about refugee and migrant justice? 2 points. First of all, if you give an update on where the LSC is with the casework they took on from RMJ, and also to explain how it is planning to deal with those areas. My constituency is one where RMJ provided the only legal support for asylum claimants.
In relation to the RMJ going into administration, all the cases which were with RMJ were passed on to other providers some months ago. So that was successfully transferred from the RMJ to other providers. I'm sorry, I should know which constituency you were, but with you coming today on the committee, so Ipswich. Ruth, do you know exactly who provides in Ipswich?
I mean, I'm not asking specific, but
no.
Are you caught up in the backlog? Because my impression is that isn't the case. Okay, so when is the backlog likely to be cleared? Because it's preventing many people's claims, many of whom have been sitting in asylum queues for 9 years in some cases, from being heard because of the problems that have been caused. I mean, do you have a date by which point the backlog will be cleared?